All right, guys. So does anybody have any comments on the video? It was relatively short, but to the point. Abigail?
Yeah, so I think that video kind of showed how negligence and liability is displayed in sports, especially in regards to the settlement at the end. That was like 19 million divided between 300 and some players. If a head injury over a long period of time was happened like in a regular workplace at like a factory or something like that, I think you'd see a much bigger settlement. But I think because the line of liability kind of gets blurred in sports. I mean, obviously, you'll probably get head injuries fighting in hockey, but you don't necessarily know that it'll be to that extent. That line's kind of blurred. It's you see like less subtle settlement.
Yeah, good points. And we're gonna see a lot more of this in the class. We're going to be dealing with it, particularly with respect to the NFL, which is where, in fact, the diagnosis of CET came about. So I think that the concussion is the video I'm going to have you do for your film study, but it's going to be about this, and it's really, really well done. Shivani?
So the video was disheartening, and I'm ignorant to Canadian sports, so I've learned a lot from this video. But even though the sciences doesn't correlate with the claims that the NHL, I think NHL, that's what it's called. Yeah, the players in
Yeah.
yeah are making, like, they're making, like, a reasonable person could draw the conclusion that, oh, like a head concussion could lead to brain damage regardless of what the directors are denying this. Furthermore, why would they market violence in the sports? And it's not like it's a wrestling sport where the aim is to pin down an opponent.
Oh boy. Well, if you've ever watched hockey, violence is a really important part of the sport. And so it's a contact sport. So this kind of thing is something that obviously has evolved over time. It used to be, if you were a hockey player 20, 30, 40 years ago, actually you didn't even have helmets 40 years ago. You got these kind of injuries and they were just taken for granted, right? So now it's not so much that it's taken for granted. But it's a pursuit of how to compensate those who actually suffer these kinds of injuries. So we'll talk about some more. Thanks, Ronnie. Any other questions about or comments about the video? Are we good? All right, guys.
I have the
Again.
next question.
Oh, sure. Go ahead.
So at the end of the video, they stated that the individuals wanted to pursue a class action lawsuit against the NFL, yeah, but
NHL, yeah.
it was ineffective, right? But
Right.
it was ineffective because it was conflicting with the state's law. So they decided to like sue individually. So I wanted to know if it was effective.
Effect? Oh yeah, absolutely. So what the video said at the very end was that they tried to put together a class action lawsuit, but they had difficulty because the law was different from states to states. And remember, we talked about that last week in class, dealing with the law. In that, when you deal with jurisdiction, for instance, how do you coordinate a lawsuit when somebody, for instance, somebody who plays for the Toronto Maple Leafs is in the province of Ontario, somebody plays for Buffalo Sabres is in the state of New York. So it's a very complicated kind of thing and hard to pursue. So what the players have done individually is they have, issued individual actions for their own personal damage. So it's not a class action, which is one lawsuit bringing together some kind of claim for everybody. It's everybody doing it differently. And almost all of those have settled, right? I mean, there's no question that the NHL eventually recognized that, they were, as a league, had a responsibility to the players. We're going to talk about that tonight because as a league, they had what's called a duty of care to the players, and that's a fundamental concept in negligence law, and as a function of having that duty of care, and then not meeting what's called the standard of care. And again, we'll talk about this tonight. They were liable, and in fact, they virtually settled all the individual lawsuits, and they're still ongoing. There's still players now who probably played for 15 years. That's a long time for the NHL. It's a relatively short window of opportunity for players. That there's certainly players who are still going to suffer from CET, and then seek to have some kind of compensation for it, mostly for their family, because if you've got that, in an amazing number of cases, it leads to suicide because it becomes so painful. mentally painful to deal with the disease. Any other questions? Thanks, Shwani. Any other oh, Kara?
Yeah. What just surprised me the most, I think, was the timeline, because the Ewan's suicide was dated to 2015, but checking the YouTube video date, it said it was about less than 2 years ago. So I just found that wild that the NHL 2 years ago still didn't recognize CTE as being like a prominent, worrisome issue in their sport. Because, like, playing devil's advocate, like, most of us understand, like you said, that's the name of the game, and you know what you signed up for, many could say, and violence is and contact's a huge part of the sport. Maybe not right now with COVID, I know, to many fans' dismay, but has that changed since 2019? Has the NHL?
No, the NHL, and we're going to see this in other parts of the course when we deal with things like doping and what have you. The NHL has always been really, really slow in in being innovative, accepting responsibility for this kind of thing, or in the case of doping, putting in place rules that actually penalize players who are caught doping. So it's and that's purely a function of Gary Bettman, who is the he's the commissioner of the NHL. But that position, his position is a paid position from the owners. So the 30 teams in the NHL, they pay his salary. So he's not there for the players. He's there to protect the interests of the owners. It's a contest between the billionaires and the players who are the millionaires. And he's 3 times now in the last 12, 15 years, he's locked the NHL players out on a strike, and we're going to talk about this later in the semester. And he has always crippled the Players Association in those lockouts, and as a function of that, put more money into the pockets of the billionaires who own the NHL teams. So we'll see. We'll come back to Gary Bettman quite a bit, but he's been there for a long time, and he's not going anywhere soon because the owners of the teams just love to have him because he's ruthless when it comes to protecting the owners and not protecting the players. And we'll see that again later. Any other questions, comments? All right, that's good, guys. Thank you. All right, so let's go to the PowerPoint for tonight, which is on negligence and liability. So let's bring it up. All right. Okay, so here it is. So tonight, negligence and liability. All right, so when we deal with negligence, we're dealing with what's called the law of torts. You guys remember in the very first class, I indicated to you that there really isn't a specific law of sports, right? There's no such thing as sports law that is unique to itself. What it is a combination of a number of substantive areas of law: tort law, the criminal law, other areas of civil law, contract law, intellectual property. Those are all substantive areas. And negligence is part of tort law, which is really, really important for sports. So anybody want to just pop up and say what is a tort? Just a one sentence answer. Anybody? Abigail?
It's like a non-criminal harm.
Very good. Yeah, exactly. It's all right. And then hang on, let somebody else too. So Shivani as well.
I raised my hand by accident, sorry.
Oh, okay, that's no problem. Okay. Yeah, so Abigail, you're absolutely right. It's a non-criminal, as in civil, harm or wrong. It's called a wrong, right? So it's when somebody has done something wrong to somebody else, right? They didn't do it with the intent to hurt anybody, right? They did it as a way of being careless, and that's what negligence is all about. Negligence has only been around for about 120, 130 years. Before that, the only kinds of torts we had are what were called intentional torts. So intentional torts are things like trespass is intentional tort. Assault and battery is an intentional tort, not the criminal assault and battery, but the civil assault and battery, which leads to damages, where a criminal assault and battery leads to charges and punishment. Okay, so keep those things distinct. There's all kinds of intentional torts, but negligence really didn't exist until about the 1880s. And the reason it came into existence fundamentally in the United States, but also a smaller degree in Canada, and similarly in the UK, they were becoming to have just monumental numbers of people who were being injured in the two major money-making enterprises in the world at the time, which was building railroads and mining. Right, and mining is from around the world, and railroads were obviously a function of, the expansion of the U.S. West, the expansion of Canada and Confederation. Sir John A. Macdonald and his railways, and in the UK as well, they have a tremendous rail system, and people working on the railways and or in mines were always being hurt. Right, they were very, very dangerous occupations. And so what ended up happening is that it became a relatively common event for people being hurt because there was no such thing as workers' compensation. So you couldn't automatically be off work due to an injury and get paid anything. That didn't exist at all. So if you were off work, you got nothing. So a business grew up amongst lawyers for the most part to in fact act for these workers, a lot of them in class actions, against the owners, the rail barons, the ones that own these big railway lines, and the mining magnates, the people who owned the mines. And it became pervasive. I mean, because it was really the only way these people who were hurt could get any kind of compensation to protect themselves and their family, especially if they were seriously hurt and couldn't ever return to work. And so, that created essentially the law of negligence. And because, what grew up is that if somebody was hurt on a railway working for one, or hurt digging in a mine, they weren't hurt because somebody intentionally hurt them, right? Nobody meant for the mine walls to collapse, or some piece of machinery crushing them in a railway. None of that was intentional. It was all by accident, right? And so the law moved from having to show something that was intentional to making a jurisdiction environment for accidents, and that's how negligence came to be. It took about 50 years after that, into the early 1920s, for all of these countries, the U.S., Canada, and United Kingdom, to put in place workers' compensation. Right, so that's when those first schemes came into place. And again, that was a function of the very, very wealthy owners of the railways and the mines going to their friends in government and saying, look, please put a stop to these lawsuits. We will pay into a plan where if people are hurt on the job, they will get some kind of compensation. And as long as that compensation is available to them in a plan, they can't sue us. And that was how workers' compensation basically came to be. So while it was a very new tort 130, 40, 50 years ago, and relatively small compared to the whole law of torts that had evolved for centuries, again, the English common law, easily since the Magna Carta, 1215, it went from being very small at the end of the 1800s to being now the predominant tort. Right, 95% of all tort actions now deal with negligence. So anybody in a car accident, for instance, that's negligence. Right, automobile accidents are part of the law of negligence, because people don't get into car accidents again on purpose. They're almost always the function of somebody being careless. All right. So negligence applies in situations where harm is caused due to the carelessness of an individual. It could be a company, it could be a government, but it involves carelessness. And what happens is that when somebody brings a lawsuit for negligence, the court determines what the standard of care is, and I'll explain to you what that is in a few minutes, that applies in the circumstances, and determines whether the person who's being sued, the defendant, who is the person who caused the harm, whether they fell below that standard of care. All right. If their conduct does fall below that standard, then there will be a court order for compensation. It's called damages, for the most part, for any of the injury or harm caused to the person. And there must be damage or injury in order to be liable for negligence. So if somebody, is negligent, they carelessly leave a ladder in a factory and somebody trips over it and falls down. If they're not hurt, right, even though the person was careless leaving the ladder there and they had a duty not to leave it there, right, and they fell below the standard of care because you shouldn't leave a ladder there. If somebody isn't actually hurt, then there really is no liability for negligence. So that's a requirement. And there also must be a direct link between the person who caused the harm and the person who actually received the harm. And I'll give you some more details of that in a second. So these are the four basic elements of negligence. These are the four things you have to have. You have to have what's called a duty of care. You have to have a standard of care. There has to be harm caused leading to damages. and there has to be a link or a causation of the harm between the person who caused it and the person who suffered the harm. Okay, so duty of care is the first thing you have to have, and the duty of care is quite simply this: anybody suing for negligence must establish that someone owes a duty of care to the injured party. All right, and think about it. Um, I teach this course to you, so I have a duty of care to teach this course to you, in accordance with what I agreed to teach you as set out in the course outline, in accordance with what you agreed and paid for by paying tuition. So hopefully what I teach you in this course on sports law is what you anticipate paying for, right? So I have a duty of care to you to give you a course that is not below a standard of care, which would be, a standard of being a good professor kind of thing, all right? However, somebody taking a course in the spring semester for visual arts, right, or for music, I have no duty of care to them, right? I have nothing to do with, even though I'm a professor at the university and there are students at the university just like you are, right? I don't have a duty of care because I have nothing to do with delivering to them knowledge in the visual arts or music. All right, so, but I do have a duty of care to you because you're my students taking a course on sports law, which I've developed. All right, and certain relationships, and now that we're talking about in the sports world, have clear duties of care. So, pay attention to this because, we're now talking about sports law. So a coach has a duty of care to his or her players. He has a number of duties of care, actually. It's not just one. There's a number of situations in sports where the coach has to ensure that he or she does something of a level that is safe as to not cause harm to the players. All right, so there's a direct relationship, and that's really the key to duty of care. There has to be some kind of a direct and close relationship between the person who has the duty and the person who is, who's receiving the benefit of that duty. All right. Arenas, so that's a picture of an arena with a stadium in it. The stadium has a duty of care to the customers or the fans who go to the stadium, right? If you go to a stadium, you pay your money. It's incredibly expensive to go to a sports stadium these days. So you pay your 40, 50, 60 bucks to get in for whatever the sport's going to be, whether it's football or baseball or hockey, right? Well, when you pay to get in there, right, the people who run the stadium, who own the stadium, have a duty of care to you as fans that you won't be hurt, when you go into that stadium. So the seats won't collapse, the stadium doesn't collapse on you, right? Or balls, don't leave the field, and hurt you. So for instance, if you're watching a Major League Baseball game, right, and then this has changed over the course of the last time, immediately behind the catcher and the batter, right, which is where the umpire is. So the pitcher is throwing the ball. Immediately behind the catcher is a net, right? And that net protects all of the fans who are right behind the umpire from the ball being a foul ball or a tip coming straight back, and it comes back at 100 miles an hour, coming right back towards you. And so the stadium owners put up this net to keep those balls from hitting you. And over the course of time, originally, first off, nets weren't always there. Nets weren't put in place until probably the 70s or 80s. So if you had a seat behind the batter, chances are 3 or 4 times a game you were ducking because the ball was coming right at you, right? But you took that as part of the excitement of the game, and you accepted that. And maybe you brought yourself a baseball glove just to be really on top of it, but it was still a pretty risky place to be. So the 70s, 80s, they put the net up right behind the batter, which is right behind the catcher and the umpire. So, right, that's where they are. And then as time went on, the net started to expand. So the owners of stadiums put the nets out towards third base and the first base, so that a foul ball wouldn't be a foul directly backwards, but a foul to one of the infields, but in foul territory. Again, those people would be protected, right? Because initially just putting a net behind the catcher didn't protect anybody who's sitting out there behind first base or third base. And now these nets go almost right out to the outfield, right? So their owners are being really careful about making sure that that fans who are in the stands aren't going to be hit by balls, for a fair distance from where the ball may be hit, which is up from the batter's box. Okay, so that's because the owners of the stadiums assumed that they had a duty of care not only to the fans right behind the catcher, but out where first base is and third base and the outfield. All right, that's a skier on a ski slope. So you have ski resorts having duties of care to patrons, skiers who ski their slopes. So that's why if you're a skier and you're going to a really decent place to ski, not there's very little. That's not Search Mont in here, or even Blue Mountain in Collingwood. Those are all very small hills for skiing, or Mount St. Louis in Barrie area. We're talking about Banff or other places in the Rockies, or Whistler in British Columbia, where you have great places to ski. But I guarantee you, if you go out there, you're going to find various parts of the ski hills that are, first off, they have parts that say Black Diamond on them, which means you've got to be a really good skier to go on this particular trail. So if you go on there and you're not up to a Black Diamond level of skiing, then it's your own fault for not paying attention to the sign, right? And then there's other signs that say, avalanche danger, do not ski down the back side of this mountain. And people do that. They do that anyway because they're stupid, but they do it. And then every year, there's got to be a dozen people every year killed in avalanches in Alberta and British Columbia because they don't pay attention to the signs. They are so excited about skiing in powder, essentially, that they'll take that risk, and they're taking the risk that day there's not going to be an avalanche. All right. But having said that, the ski resort still has a duty of care, for the vast majority of people who pay to go on their ski lifts, to make sure that they're safe while they're there, right? The test as to whether there's a duty of care is called the reasonable foreseeability test. And this is what it is. We only owe a duty to be careful to those people who we can reasonably expect will be harmed by our careless conduct. All right, so again, think about me as your professor, right? I have a duty of care because it can be reasonably expected that I will harm you if I don't teach you properly, okay? There's no reasonable foreseeability that I would do harm to anybody in the music or the visual arts department. I have nothing to do with them, okay? So that's a pretty straightforward concept, right? And if there's no duty to care, duty to act, right? No duty of care, then there is no action and negligence. So in no circumstances can anybody in visual arts or music sue me for negligence, for whatever they're being taught in their class. Now, you're going to find this interesting, and it's absolutely true, that a doctor has no duty to stop and render assistance to somebody hurt at the side of the road. That is the law in Ontario. So, a doctor, say it's a GP, right? It doesn't have to be a GP, it can be a specialist or what have you. If they're walking down a sidewalk and there's somebody lying on the side of the sidewalk and their head's bleeding and they're groaning and they're obviously in pain, that doctor has zero obligation to bend down or kneel down beside them and try to administer health care to them. Right? That is not the law of Ontario or most of Canada for the most part. They can just keep on walking. So, the fact that they've seen this person, even if they stood beside them, as long as they didn't administer any kind of care, then they haven't created a duty of care, as in they haven't created a close relationship with that person on the sidewalk in order to have fundamentally changed the relationship from one of not having a duty to, in fact, owing a duty. However, if the doctor does stop by the person and then gives them assistance, actually bends down, and you would hope that 9 out of 10 doctors would actually do this, that they would, in fact, kneel down and start administering health care to somebody who's hurt. The minute they do that, right, they have now in fact created a duty of care. All right, so they are the makers of their own misfortune or fortune in regards to whatever they do to this person, and hopefully they don't treat them negligently and be sued for whatever care they give. All right, so there are places where in fact you cannot walk by somebody who's hurt, right? And they put in place laws that are called Good Samaritan laws. The Good Samaritan is a biblical figure, right? In the Christian church, it's a biblical figure. So there are lots of states in the U.S., no provinces that I know of in Canada, that have Good Samaritan laws in place, which basically put obligations on people to stop and try to help people who are suffering in some manner. For instance, if you see somebody drowning, again, you have zero obligation to go out there and try to save them, right? And if you're not skilled at what you're doing that, if you're not a trained lifeguard or no better, your chances are just as good as not that that person is going to take you down with them, right? You have to be very, very careful in trying to rescue a drowning person. But again, just like the doctor who can walk by an injured person, in Canada, for the most part, there are no laws that obligate somebody to go out and try to save somebody who's drowning. Although most of us, I would think, if we're within a reasonable proximity of them on a beach somewhere, that would be our natural tendency to try to get out there and save them, right? But there is no duty of care to do that. And if you do that, then believe it or not, you've created a duty where you in fact have to do the job properly. You have to do it carefully, or you can be sued for negligence, likely from the estate of the person who's drowned against your estate because you've gone down with them. All right. Okay, so that's duty of care. So let's next deal with standard of care. So the standard of care is this: once in fact there has been a duty of care established, so there is a close and direct relationship, so that somebody in fact has a duty to take care of somebody else and not be careless. Once that's established, then the standard of care that they provide this person has to be one that is of a level that is not negligent, right? So the question is, how careful does a person have to be? And that gives us what's called the reasonable person test, right? The reasonable person test is pretty straightforward. A person is negligent if there is a failure to do what a reasonable person would have done in the same circumstances. Okay, so it doesn't require perfection. You just have to do what's reasonable in the circumstances. And it's not necessarily what an average person would do either. It's the standard of a prudent, careful person. Okay, so that doctor who stops beside somebody who's injured on the sidewalk and bends over and starts administering healthcare, that doctor has to do so of a standard that is, is standard of whatever kind of doctor they are, right? Being careful. So if it's a GP, they're going to have a pretty good idea of what to do. If it's a neurologist, maybe they don't know as much as a GP. I don't know. If they're a cardiologist, I don't know. But they have to be as careful as an equivalent person with the same credentials has to be to look after that person. Okay, and that's the test, right? So the standard is that of a reasonable person in the same circumstances, which just kind of makes sense. So a doctor has to do what a reasonable doctor would do in the same circumstances. A lawyer has to do what a reasonable lawyer would do in the same circumstances. So for instance, for a lawyer, when I started practicing a long time ago, most lawyers in Ontario were generalists, right? They had a bit of a general practice, which means that they did a little bit of everything. Did a little bit of real estate, did some wills and estates, they did some civil law, some tort, litigation, they did some criminal law. Over the course of the last 40 odd years, which is as long as as long as I've been around doing this kind of stuff, you now have more specialists than you do generalists. So if most lawyers now don't call themselves generalists, they call themselves criminal law specialists, estate law specialists, real estate practitioners. They basically focus on something that is one field, and they do that as excellent as they can. All right, that's really important because sometimes it still happens, particularly in small towns. So in Sault Ste. Marie, which is relatively a small city, you still have a number of lawyers, and you see these on billboards around town. You see a lot of them who Feifel and Galatsi do a lot of personal injury, and that's all they do, and that's fine. But there's a lot of lawyers. There's a sign for Mark Palombi on Albert Street, and he says he does criminal law and estate law and real estate and what have you, right? He does a lot, or Wilson Greco, estate law, real estate law, criminal law. So they still do a bit of a general practice. You have to be really careful about that, because if somebody comes through the door and they've been charged with an incredibly serious crime, right? Then if you take it on, you're taking it on the premise that you're absolutely qualified as a criminal law specialist to do the right thing for this person who's been accused of a crime, which means you have to know, for instance, the charter inside and out, because the charter is what protects accused from the power of the state, right? So, and that's why, of the systemic causes that lead to wrongful convictions, which is a whole different course that I teach, ineffective assistance of counsel is one of those systemic causes, right? So of the 7 reasons that people are wrongfully convicted, and this is around the world, one of those reasons is that the defense counsel didn't do a proper job, and in fact, fell below the standard of care for what a lawyer in that position should have done, all right? Same thing for a plumber. A plumber still has to do what a plumber in reasonable circumstances would do. So you call in a plumber because there's a leak in your house, which is a fairly regular or mundane kind of harm being caused, the plumber should be able to fix that. If the plumber comes and he or she is so inexperienced, they don't know how to fix it, so they just do something that for the time being maybe stops the flow of water, and then 5 hours later in the middle of the night it breaks wide open and does all kinds of damage, then the plumber didn't do what a reasonably prudent plumber would do. So they'll be liable in negligence for that. Okay, so it's pretty straightforward. So here's what skilled coaches have to do, because they have that duty of care to the players, and here's their standard of care. So they shouldn't put somebody into a game that they know is outmatched or were previously injured and will be further injured if they keep playing. And that's something that most coaches are very careful about these days. But it's not that long ago where a coach would send a player back in who's actually been hurt because they didn't want to lose having to skill that player on the field. That's not a very distant concept. So a skilled coach wouldn't allow an injured player to continue playing. All right. Here's a video, and the rest of the class, we're going to have quite a few videos, which is the great thing about sports law. There's lots of them. So here's the 10 of the worst sports injuries caught on camera. Oh, it's not going to, oh, it's really? Oh, shoot. It's not going to let me do it because it has to be on YouTube. Sorry, guys. I hope that doesn't apply to all of them, but let's try again. Nope, can't do that one. Okay. All right, sorry about that. Okay, so anyway, going forward, how do you prove what is reasonable? So if somebody is suing somebody else for negligence, if you were going to court, if you were the plaintiff, what would you do to prove that the person who you're suing was not reasonable? Anybody? Any ideas? Who would you call in that regard? Shivani?
A reasonable man.
I'm sorry?
A reasonable man.
Well, all right, you would call
a regular citizen.
I'm sorry?
A regular citizen?
Well, not regular citizen. You would call somebody who can give evidence as to what is the proper standard of care, right? If you're suing somebody alleging that that somebody has not lived up to whatever their standard of care is, then you would want to have somebody give evidence as to what that standard of care would be. So again, if a doctor was being sued for negligence, you'd call another doctor. If it was a lawyer, you'd call another lawyer, that kind of thing, right? You have to prove that. Right? So if it's a coach, you would put another coach on the stand in the particular sport you're dealing with, right? There are a number of factors which are part of what constitutes a reasonable conduct. And these are the things we have to pay attention to. So there are what are called written standards, unwritten standards, case law, and common sense, right? So some of these you're very familiar with because we talked about them last day. So written standards, that everybody has and it has to pay attention to they include statutes and regulations, right? Obviously laws that are enacted by Parliament, or if it's provincial, by the provincial legislature. Building standards, so municipalities are responsible for building standards. So the city of Sault Ste. Marie is responsible for the center downtown. So the arenas kind of thing. So there's building standards with respect to those arenas being built. Equipment standards, so the Canadian Standards Association, when you look for equipment, hockey helmets, football helmets, gloves, shoes, what have you, you look for the CSA sticker on them, which tells you that that particular piece of sports equipment has risen to the level of approval for the CSA. There are policy manuals, safety protocols for all kinds of sports, and of course the rules of the game itself, right? And everybody who plays sports has to know what those rules are, even if they're not part of a statute or a building code or what have you. So rules are almost always posted wherever you're playing a game. So for instance, on a tennis court, there should be rules as to playing tennis and the etiquette of playing tennis. They should be posted somewhere inside the screens where you're playing tennis. You also have unwritten standards. These are standards that are common but not written down. So things like if it's raining on a golf course and it's going to become a storm with lightning, then you stop playing golf. You don't go under a tree because that's what lightning hits, and you get away from your clubs because they're metal. Right? So you want to get away. You want to get as far away from high objects and metallic objects, so that you're not going to be hit by lightning. So hopefully this one I can show you.
It was an enormous crack. He was not moving. Kind of bluish-like, mouth half open, not breathing.
New tonight, dangerous lightning strikes down a man on the golf course. The golfer's friend springing into action to save his life. Good evening, everyone. Thanks for joining us. I'm Wendy Ryan.
I'm Paul Legrone, and all new at 5. We're just finding out the man's name. ABC Action News reporter Lauren Rosella live at the Clearwater Country Club where that lightning struck. Lauren.
Clearwater police telling us that the victim in this is 76-year-old Frank Sink. They are now telling us that he had just stepped off his golf cart right over here at the 7th tee when the bolt struck.
Just that one boom, that was it.
A game of golf turning into a nightmare for a group of 3 men Friday. A man struck down by lightning just as the rain began.
It was an enormous crack.
Walter Stats heard a crack and turned around to see his friend on the ground, his Bluetooth headphones blown right out of his ears.
He was not moving. Kind of bluish-like, mouth half open, not breathing. We need to help him.
Walter and another golfer in the group rushed to their friend, administering CPR and waiting for paramedics to arrive.
I'm going to get him CPR. He doesn't look like he's breathing. Well, I said, I'm going to call 911.
Golf course officials saying the man had a pulse when emergency workers took him away. Walter still shaken, seeing Florida's powerful lightning firsthand.
It could have happened to all of us, any of us, all 3 of us.
Grateful tonight he's still alive.
All right, and you guys are pretty young. Most of you probably don't golf. I certainly do, but it happens still all the time. You always hear stories of people hit by lightning, and you hear stories where the same person is hit like a number of times over the course of time. So it's kind of a crazy thing. Case law, again, are rules you have to follow. Now you guys know all about case law. We spent a lot of time last week on the common law, the establishment of the common law. So, when you're looking for who's negligent and who's not, one of the things you look at is, or are precedents in similar situations and apply those same standards. There's very few accidents, as a function of negligence in the sports world that haven't already happened before. And that's a precedent. And the precedent is applied by using the common law in the situation when you get to court, right? And then you have common sense. Right, so it's there's some cases where a total lack of common sense is in fact stupidity, right? So you simply let something happen that no one would reasonably let happen. So that's clearly something that is negligent, and if you do it, if it's stupid, then the liability shifts from the person who caused the damage to the person who actually created it. So here's a video. Hopefully this shows. It's called the German Ice Diving Fail.
Willst du noch eine Rede halten?
Hand hoch. Alles klar. Das kannst du mir gleich geben. Ich ziehe mich da gleich sofort raus.
Warte, ich filme das Wasser, warte. Eis hier überall. Ja,
ist egal, überall rein.
In der Mitte am besten da.
Ja. Ich will nicht mal gucken, nicht dass das zu hart ist. Nicht drauf?
Ja.
Motherfucker, fuck the fucking world, and my new band is called Siskill. Oh, mein Arsch. Oh, guck mal, es geht gar nicht runter. Perfekt, oder? Aua.
Okay, so clearly part of that German didn't need to be translated for you, but believe it or not, the owner of this pool had a duty of care to this guy, right? That he wouldn't be hurt, right? And the duty of care, what says created then gives rise to a standard of care. So, what is the standard of care that the owner of this, pool, which is obviously frozen over, has to this person? Anybody, any ideas? If you owned this pool and you saw this person there who's on your property to which you have a duty of care, and they're about to do this dive into he obviously expected to break through the ice. That was the whole idea of this. It didn't obviously go that way, But what would be the standard of care you would have? Anybody? If you own that pool? Kyle?
Wouldn't it be really dependent on if he was a trespasser or if he was invited onto the property?
Well, yes, that's a side issue, but it's true. You know, the level of care, it depends on if to the level of payment the person, you know, so if he's a paying guest at this resort with the pool, right? Then you have a higher level of care than you would if he just snuck onto the property and did this on his own. But even just sneaking on the property creates a duty of care. So let's take it to the upper end of the scale where he is in fact you know, a paying guest there. So Patricia?
Yeah, he has like an obligation to be attentive to the people that are at his house and what they're doing. So if he's like aware that the pool is solid ice, he shouldn't be encouraging his friend to jump on it because they're bound to get hurt. And then he's kind of like liable for the standard of care because he wasn't attentive to what his friend was doing and he didn't prevent him from getting injured.
Well, okay, so but you're presuming that it was his friend who was filming him, for instance, that owned that pool. Let's say he was at a resort, you know, in Collingwood, or even in the Sioux. Let's say that there's a resort that has a pool, an outdoor pool, right? And both these guys are guests of that resort. So, you know, the one's filming it, the one is diving into it, hopefully to go into the water. Obviously doesn't do that. So what if you were the owner of the resort, you know you have a duty of care to these people. They're paying guests. What would you do to try to prevent that from happening?
Right. So they should have had somebody on guard then, like a lifeguard or somebody who was monitoring the pool area at all times.
That's a good
And
way
if
to
there
do
was,
it. Yep.
and if there was like a solid pool of ice, then they should have put up like warning signs that the pool is solid ice, not to be jumping or running around it.
Exactly. Shivani, same thing.
Yeah, I was gonna say to put up signs to show.
Yeah, if you knew there was if you knew there was these idiotic Germans floating around your pool getting ready to do this, first off, you get somebody there to make sure they didn't do it, as in Patricia was saying, some kind of a guard. But you know, put a fence up or something around it. And if you think there's those kind of idiots that out there, obviously there are, because this is a real thing. So you know, but that's a good example of what you have to do. Even though you know there are these idiots who are totally stupid in what they're doing, right? You still have to protect yourself from being sued because say for instance, I guarantee you, if this guy who's laughing now because he hit the ice, what if he had broken his back or broken his neck and became a paraplegic, which is totally within the realm of reason? I guarantee you that they would be suing the owner of the resort, right, for negligence, for making sure or not making sure that the idiocy of what he's doing, should not have taken place. I guarantee you it would be a multi-million-dollar lawsuit in negligence, right? Even though he's clearly, assuming the risk. And that's the way litigation is, right? Good example though. Okay, so we've talked about duty of care, we've talked about standard of care. So let's talk about damages, right? So it's just not enough that somebody was negligent. There must be an injury that causes harm, and the harm would include things like pain and suffering, loss of earnings, reduced life expectancy, cost of future care, special treatments, that's occupational therapy, and drugs, what have you, for pain, all those kind of things. So this is, if you think about it, it's just like, well, it's like a car crash. Right? These are all the things that can happen in a very serious car crash, where somebody can be crippled for life. Right? First off, there's going to be a lot of pain and suffering for whatever harm that's been caused. They're not going to be able to return to work. Sometimes, maybe not ever, but certainly for a certain period of time to recoup from their injuries. If it's a life-threatening disease or harm, it may limit your life expectancy. You're going to need future care. So that's maybe nurses come into your home depending on how serious the injury is. You guys can imagine all these things. So all of these heads of damages, that's what they are. Can apply both to car crashes or this guy trying to jump through the ice in the pool. So again, duty of care, standard of care, and there has to be harm caused that leads to damages. Right? And then you have causation. This is the link. So the test that's used to determine whether there's a sufficient causal connection. And remember, all of this stuff, all of these things we're talking about, these elements of negligence, just keep thinking about them in the field of sports law. right? The relationship between, you know, coaches and players and stadiums and fans and players and fans and, you know, all the kinds of relationships. And, you know, even referees have a duty of care to the players, those kind of things, right? So think about all those kind of things and think about the duty of care that arises, what standard of care do they have to live up to so they're not careless. And, you know, and there has to be a causation, which means that the person who, you know, is harmed, you know, can be linked directly to the person who causes the harm. That's causation. And what is used is what's called in the quotes, the but-for test. And the but-for test is this: the plaintiff must show, that's the person who's been injured, who is suing the defendant, must show that but for the defendant's careless conduct, the harm or loss suffered would not have taken place. Okay, think about that. Right? But for somebody doing something else would or would not have happened. That's the test of negligence law. So here's an example. That's somebody with a bullet hole in them. Okay, so you know, A and B are at a bar, and it's a biker's bar. I don't even think we have one of those in the Sault Ste. Marie, but most cities do. If we have one, okay. But even if we do, right, and there's a dispute, and A takes out his gun and he shoots B. Right. So, you know, or he just takes the gun and waves it around the room and it goes off. He's careless and it shoots B. You know, it's not that hard to see that there's a causal link between the guy who shot the gun and this guy with the hole in him. Okay. But say, for instance, that he shot, I'm saying it's a man, he's shot in the shoulder, right? And so it's not a life-threatening kind of shot, right? It's not an injury that's going to kill him. But he gets to the hospital, right? And the surgeon who's going to take the bullet out has had a really crummy day. You know, he had a fight with his wife in the morning, or she had a fight with her wife in the morning, or husband, or whoever it was, or they went out for a liquid lunch, you know, at noon and had too much to drink and weren't totally sober when they did the surgery. Any number of things, and these things happen. Right? You don't hear about them happening, but they do happen. You know, there's a whole field of law called medical malpractice, and that's a big area of law. So anyway, so what happens is that the surgeon does something incredibly stupid, doesn't get the bullet while he or she is getting the bullet out, nicks an artery or what have you, doesn't notice it, and the person bleeds out and dies. Okay, so now you have somebody who has received a shot to their shoulder, who shouldn't have died because it wasn't a life-threatening shot or injury, but in fact they did die because the surgeon was drunk and didn't do the job properly, and as a function of that, the person bled out and died. So my question to you guys is B is A, the person with the gun, still liable for the death of B, but for the fact that they shot B? Are they still liable for the death? Patricia?
I would think so, because if it wasn't for the person who shot them, they wouldn't have had the shot, which means they wouldn't have had the surgery, so they wouldn't have died. But I'm not sure if I'm right.
No, that's a good answer. Anybody else?
Could you repeat the question, please?
Okay, so, is A, the person who shot the gun off, which resulted in the injury to the person in their shoulder, and the person who's injured died as a function of the work of the surgeon, is the person who shot the gun, liable for the death of the person who died? Was it but for the actions of the person with the gun that the person with the bullet died?
I think the hospital or the doctor would be responsible, right?
Okay, well, that's part of the answer, right? Anybody else? All right. Well, you're both right, and that's a good answer. So the answer is quite simple. This: yes, the person who shot the gun is liable, right, for the death of the person, because it was but for their actions, the person would not have been shot. However, as is likewise the case, the surgeon has liability for the death, because the surgeon participated, and but for the negligent malpractice of the doctor, the person wouldn't have died. And what happens is that then when you go through this exercise in court, you have what's called contributory negligence, which means that the court will assess, who's liable for what and what percentage of liability lies, right? So neither the person who shot the gun or the surgeon is going to be 100% liable for what they did, but they certainly are going to be partially liable because they certainly had a role to play in the death. Everybody kind of get that? It makes sense if you think it through, but it's important to have that link. Patricia?
So then would the liability be split like a 50-50? They're both like equally liable?
It could be 50-50, it could be 70-30, 60-40. That's what a judge is for. The judge will determine what the degree of liability is based on how careless was the guy with the gun who shot it, how negligent was the doctor who let him die. That's all part of an assessment, all right?
In this particular case, what would you say would be like the percentage? Because they were both pretty careless.
Again, on this fact situation, 50-50 is a good guess, right? The person who died wouldn't have died if it wasn't for the negligence of the surgeon, right? But the person who died wouldn't have, been in the hospital in the first place if it wasn't for the guy who shot the gun. So yeah, 50-50 is a good guess, but again, that's just a guess at this point. All right. So long as the injury suffered was reasonably foreseeable, right? A court will usually find that the conduct was caused by the plaintiff. And that makes sense. So a guy who shoots the gun, right, and causes the injury, courts will almost always find them liable, right? Because none of the injury would have taken place no matter what happens down the road in the hospital if the guy didn't have the gun in the first place. All right. We have what's also called statutory liability. So all of those things I talked to you about, the duty of care, the standard of care, damages and causation, those are to a great degree developed by the common law, right? So, from 1880 going forward, almost all of the things we just talked about were a function of courts making decisions in various cases that created precedent, which was followed and then expanded upon over time, right? But then you also have what's called statutory liability. And statutory liability is just what it sounds like. It's a statute, right, which is a law put in place by either, if it's federal, again, the Parliament in Ottawa, or in Ontario, if it's provincial, by the provincial legislature in Toronto, right? Those two bodies of elected officials. And so, they will, in the cases, put in place liability as a function of a statute. And the most common one with respect to statutory liability is what's called occupier's liability, right? That's the terminology for it. And what that simply means is this, and we've touched on this already. So anybody who has control of premises, stadiums, arenas, what have you, they have a statutorily obligation to be careful. Okay, so they automatically have a duty of care and a standard of care. So the law, you don't need previous precedent and court cases to determine that. The statute creates it. So if you have an arena or a stadium or wherever it's going to be where an event takes place, right, you by virtue of statute have an obligation to care for those who come into your premises. And the standard is to take sufficient care as to ensure that the visitors will be reasonably safe. And this includes the following. So hopefully you can see this. Good. Yeah, so that's the Metrodome in Minneapolis, and that's about 10 years ago. But clearly, the owners of the Metrodome have an obligation for that never to happen, right? Because obviously the point with that is that if anybody had been in the Metrodome when that happened, there would have been, and particularly if it was a full house, there would have been somebody injured just trying to escape that roof from collapsing. So clearly it's an engineering issue because it was a soft roof and the soft roof couldn't sustain the weight of what was obviously snow. It's Minneapolis, it snows more than it does here, believe it or not. So that's a very obvious example of occupier's liability where it's breached because the owners of the stadium didn't take care enough to make sure that it was structurally sound. All right. Oh, you can't watch that. I'm sorry. So this, I had, this is Trump, believe it or not. This is, YouTube is owned by Facebook. So Facebook now puts these warnings on about what you can see, and you have to go directly to YouTube. And I did upload to YouTube for the class, but now you have these warnings on here. So I won't do this again. I've never had this issue before, but now this year we do. So I can't show it to you, but this is a bleacher collapse in Brazil where 500 people were in the stands and the stands collapsed, right? So that there's about 40 people who died in that particular accident because of the poor structural integrity of the stands. So I apologize, I can't show it to you, but that's essentially what happened in this video. All right. So also statutory liability. So it relates to things like the physical condition of premises. So ski hills have to be groomed. Buildings have to be of a sound structure. Activities carried on have to be safe. So fans are safe. So for instance, you can't, if you're hit by a golf ball watching a tournament, and I mean, in the last year and a half, there's very few fans on golf courses watching the Masters or the PGA Tour events. But, players, even professional players hit golf balls that go sideways rather than straight. And so players get hit all the time. And unfortunately, that's a risk they take, but it's still up to the golf course owners themselves to ensure that there is enough safety so that doesn't happen that often. Behavior of third parties, trespassers don't cause harm. So we kind of touched on this earlier with the ice. I think it was Keel who said this, but owners of sporting events also have to make sure that people who don't pay, who try to sneak into premises, to watch events, and that happens all the time, that they don't cause harm to people who are there properly. Right? So that's all part of statutory liability. Okay, so let's see if we watch this one.
Well, here it is. Backup quarterback. Chandler Harnish throws, and Pam Oliver, wham.
All of a sudden there really have been questions about this defense, which is ranked 21st. Not having Benson is going to hurt. I had an interesting talk with offensive coordinator Tom did you guys just see that football?
I saw it.
Anyway.
The Brewers came up with a handful of great.
He's throwing darts right now.
Yeah, and I think you got a woman. So Posey knows what's going on. He watched the whole thing develop. This is the bat as it gets whipped into the stands. And you see.
And got that young man in the head. He's being attended to right now.
And that is driven out to deep left center field, and this one is gone. It's a home run. How about that pop? Pete Kozma. Welcome to Arizona, Heath Bell.
And play good defense. We really have something here. It's fastball, and look where it goes. Up to that second depth. Hits that young lady over the yellow line. She's fine, but...
Heads up! Heads up!
Oh, man, didn't quite work that time.
I tried.
Jeez.
How to play.
Annie?
face. I got it. He's bleeding. Blood pouring out of his nose.
عزمي وفيصل الجحدلي في خط المحور شادي ابو هشهش. بسم الله الرحمن الرحيم. الله يهديكم. بامبا يلعب الى اليمين. سلامات يا سعد. امام ماجد هز.
It's a serious problem, Martin. It's tackling something that is going to start to go out of the game.
Well,
now.
we hope not.
Simon Südel hat ihn am Mikrofon.
Simon Südel hat ihn am Mikrofon.
Starting it up the right-hand side, turning it a bit on that breeze, coming down close towards the tree on the left.
Oh, boy, speaking of danger, boy, we may have a problem here for one of the spectators. He's just been felled terribly by that hooking drive of Robert Allenby's.
Oh, for Bradley, that's all he needs. It's only 289 to the front. Oh, he's knocked that guy out. Oh, right on the head. That hurt. That's seriously hurt.
Oh, he goes bang. Touch of air from Panesar. And they got a touch of air from Rutherford. It's gone all the way for 6.
I think it's actually hit someone there.
Oh, he's got a sore head. He might have worn that one from Hamish Rutherford. On the ground. Didn't leave his crease, just swung through the line of the ball. And let's look out, son. Oh, it's a falcon. Oh, it's a painful one too. Was looking the other way and he's copped it.
Yeah, I wasn't even sure if it hit the bat actually. But, it's raced away, whatever it's done. And it's nailed the young man who tried to catch it. He's not getting much sympathy. He's right below us here in the commentary box, and his mates are giving him anything but sympathy. Boing. Good first touch, though. Got it down.
Now, Corey's being clocked at bowling at 138 kilometres an hour bowling indoor and 143 k an hour bowling outdoor. Now, that's about the speed that New Zealand opening bowler Shane Bond bowls at. So, I want to see if he's for real, sir. Go on, mate, bring it on.
All right. Okay, so you guys can see that happens all the time. All right. So moving on from occupier's liability, again, this is another form of statutory liability called product liability. You've probably even heard of this because it's a fairly common term, but it's really only become really prevalent in the last 15, 20 years. So what it essentially means is that the manufacturers, suppliers, and retailers are responsible for the use of goods and products. Right? And harm is usually caused by poor design of these products. So hockey and football helmets, concussions, what have you. So, you know, people who are involved in the manufacture and sale of things that are used in sports, you know, mostly equipment and which you may well wear, have to be a certain standard so that they in and of themselves don't cause harm.
There's a good jab on the face.
It's hard to imagine today, but about 100 years ago, boxing was one of the most popular sports in the US. More people went to some championship bouts than could fit into any NFL stadium today. But for boxing, it was all downhill from there. There are a lot of reasons why, but one of them is that a lot of people see the sport as barbaric because it causes brain damage.
After the most murderous beating a man ever took in the ring, and
After years of getting hit in the head, many boxers develop dementia and depression as part of a disease called dementia pugilistica. Nowadays, dementia pugilistica has a new name, CTE, and it's not just found in boxers, but in increasing numbers of football players, even causing some people to question the future of the NFL. So people have always known that playing tackle football causes injuries. Okay, I'm gonna play football and maybe I'm gonna break my legs. Maybe I won't be able to run when I'm 50. Players have known that forever, but what we didn't know is that playing tackle football can cause really long-term brain injuries. There's something a lot less sad about a 50-year-old who can't run versus a 50-year-old who can't think.
The things we do to one another, okay, hell, I don't know what I'm saying. I'm just tired and confused right now. That's why I say it. I can't really, I can't say it the way I want to say it.
Over the past few years, a number of former players have committed suicide after battling depression. Afterwards, they gave their brains to science, and upon examination, they showed telltale signs of CTE. Scientists don't yet have a way of diagnosing CTE for sure besides doing an autopsy. So apart from the 50 deceased former players confirmed to have it, they can only suspect that hundreds more are living with it right now.
978432.
978.
For a while, the NFL was completely repressing research. They were telling players that concussions were a relatively safe type of injury to suffer. But with pressure mounting, the league changed course, settling a class action suit for $765 million and pouring money into CTE research. The issue hasn't gone away at all. The NFL's been trying to solve it, and it seems like they're putting genuine efforts into it, but it just might not be possible. In theory, concussed players are no longer allowed to enter games. They've moved the kickoff 5 yards down the field, so a lot more kickoffs become touchbacks, so you don't have the high-speed impacts happen when the kicking team is trying to cover the kick and tackle the player. They've changed the rules in terms of head-to-head hits. On defense, you can't use your head or your helmet as a weapon. If you're a running back, you also can't lead with your head to hit other players' heads. Those are the easiest things to target. They're kind of the lowest hanging fruit. They can't get rid of concussions entirely, those rule changes. Some concussions happen on the most random incidental plays. I mean, you have these huge, fast guys running at high speed, so even if you ban specific types of hits, we're still seeing concussions happen with alarming frequency. There's another problem. Even if they got rid of concussions completely, some of the scientists think that subconcussive hits, so even milder type of hits that we might not even notice watching on TV, also lead to CTE over time. They're still trying to figure that out, but if that were true, that would basically mean that the game of football as we know it is fundamentally unsafe. The NFL is more popular than ever. The Super Bowl gets over 100 million people, so that's a third of the country watching it. And just on a week-to-week basis, more people watch football than any other sport. It's more popular by an order of magnitude. But lots of parents are worried about the safety of the sport. A lot of people have come out and said they wouldn't let their kids play football because of the health risks.
In fact, if I had a son, I would be real leery of him playing.
The number of kids under 16 playing tackle football nationwide seems to be declining, and some state lawmakers have even proposed banning it for kids under 14 entirely. It's unlikely that people are going to just turn off the TV because they realize that sport's unethical. What's going to kill football, if it dies, would be parents not letting the next generation of players put on a helmet.
Got to find a way in this game to help eliminate that play right there, and I don't know how you do it.
And again, we're going to deal a lot more with CTE and now before the end of the semester. So we're going to see a lot more of the NFL because it's the leading focus or location of brain injuries as a function of playing the sport. This is a really cool, it's called Cool Science. This is done by a kid who examined helmets and which ones were the safest with respect to injuries. So we're going to watch this for a few minutes, and it is pretty cool.
9-year-old Jack Leibold, right, Steve?
9-year-old. You know what? If the third grade teachers across the world are producing kids as good as Jack, we're okay. We can retire. We're going to be just fine.
There you go.
They'll take on the whole world. So absolutely. All right. So Jack, would you tell Mark kind of what your thought was behind this whole thing? Because you did this as a science fair project, right?
Mm-hmm.
So how did you think about it?
Well, I just thought it would be a good experiment
for my science fair project, and I was really curious what would happen if
It's all
I
about
did it.
which helmet is the best helmet, right?
Yeah.
I know parents are just frantic about this because I know we get a lot of that question, you know, what should I buy? So
Yeah, and he invited me to wear the test helmet and then crash, but I thought that would probably be,
passed.
yeah. So you used melons instead, is that right?
Yeah.
All right, should we show them kind of the behind-the-scenes testing a little bit?
Yeah.
Take a look at, let's roll our secret video and show them our testing facility. Take a look at our video and watch. All right, well, here we are at the world-famous melon testing facility. All right, we're just in a parking lot, but this is Jack Leibold right up here. All right, you ready, Jack?
Yep.
Do you have the test victim? All right, here it is. Here is the, do you have a name for the melon?
No.
You don't name the melon? All right, here we go. You ready? 3, 2, 1, drop. Oh, this is so good. I think that there's a small problem. All right, I'll get it cleaned up. All right, here's round 2. All right, but this time he's gonna put the helmet on. All right, protecting the melon. All right, you ready? All right, still no name?
Nope.
No name. Okay, you better move over a little bit so we don't smash that poor guy. All right, here we go. Ready? 3, 2, 1. Is what we'll show you here in just a second. So, Jack, you did that with a whole bunch of melons, and we're going to show them that one in a second. But kind of show us what you did here. So let's tell them the kind of helmet, and then show them what happened when we dropped it, okay?
It is a football helmet, and I dropped it, and it has this.
Not good results.
This is not good for a person. But this is not really, you said a full contact helmet. This is more of a decoration?
It's not really meant for contact.
Okay, well, I think that this proved it, all right?
Yes.
And then what is this one?
This is a skateboard helmet.
Okay.
And I dropped it, and I got this.
Oh, for heaven's sakes.
Wow.
That's
So
kind of scary.
now you just put it in here and dropped it this way, right? So when it
Yeah.
hit, they all hit like this,
Mhm.
and then this is kind of what happened to the melon. You tried to make sure that all the melons were about the same size, and,
Yeah.
and you bought them at the same time. All right, should we show them the one that you actually dropped at our office? All right.
Yeah.
So show them this one. Let's take this guy out here. What kind of helmet is this?
This is a ski helmet.
It really fit well inside. That's another thing that we have to show. Okay, turn that one and show.
And we have another
Even
crack.
the good helmet that
my
was here.
gosh.
All right. All right, so let's take a look at this last one over here.
That
I'll kind of
surprises
move it
me,
over
'cause-
and show them what this helmet is.
This is a bike helmet, and we dropped it, and the helmet just got destroyed.
Boy, it
Right.
did, didn't
So-
it? Which is
But-
part of the way it's supposed to work.
Yes,
right?
but look at this. Can I show them this?
Yeah, it has
Look.
no cracks at
No
all.
cracks at all.
Boy, that gives you some comfort.
So what did you learn with this one? What was the secret or the science behind this one?
I think the fit of the helmet makes a big difference.
Right. And the other thing I think that we were talking about is that this took the impact. This did exactly what it's supposed to do. It cracked instead of your head cracking or in the melon cracking. This took the impact. So even a couple hits there, but it's, you know, you're involved in some sort of accident or whatever. This did its job, and now, of course, you'd get rid of it and do a new one. But I thought that was an amazing. And you know what I'm most impressed about, Jack, is the fact that you had a scientific test for every one of those, and you gave us all the information. We're going to put it up on the website so you can see the whole experiment for a science project. A+, blue ribbon,
Budding
whatever
Steve
it might
Spangler,
be.
9
My
years old. That is
gosh.
an excellent experiment, and it will cause a lot of people to rethink their helmets. I know I'm rethinking mine.
Absolutely.
All right. Okay. Okay. So again, back to statutory liability. So once causation has been proven, the court will turn to look at any responsibility of the plaintiff for the injury. So think back to that German guy jumping on the pool. Okay. So now we're talking about responsibility of the plaintiff in causing their own injury. So if the plaintiff has had some part in causing injury to himself or herself, then they will have seen to have been contributory negligent. And the way the common law was, right before the Negligence Act was put in place in every jurisdiction, is that if a plaintiff who was injured, you know, at the risk of somebody else's harm being caused, they would get 0 in damages. Even if they were only 1%, you know, contributing to their own injury, they got absolutely nothing, right? So these are the things that, for instance, if you're going to be injured, you have to kind of do these things to prepare yourself to not be injured, right? You have an obligation to protect yourself. So, you know, should a helmet have been worn if you're a cyclist? And we saw in that kid's video, you know, that helmets for riding are actually quite safe. That's a good thing. If you're playing squash, should you wear eye gear? And clearly you should, because squash balls and squash rackets, which are swung pretty widely when you're playing a game, you know, if you're hit in the eye, is going to cause a lot of damage. Or if you're playing a sport and you've had you've had some alcohol or you've had some pot some dope, right? Anything that diminishes your own capacity to, weigh what you're doing, it will lead to your own negligence. So again, at common law, if there was any contributory negligence, there was zero recovery for the plaintiff. So if you had anything to do with it at all, then you got nothing. But, over the course of time and in the last 50, 60 years, all jurisdictions in Canada, which means all the provinces and territories, by virtue of legislation being the Negligence Act, that's what it's called in Ontario, basically what it does is it gives the judge the authority to determine a percentage. So not unlike what we talked about before with the gunshot and the percentage being shared between the shooter and the doctor. Well, this is again the same kind of concept. The obligation for damages is shared between the plaintiff who has been harmed and the person who causes the harm. And and a percentage will reduce a claim, right, accordingly, right? So before we get to victims, so what happens is essentially is if somebody is injured in a car crash and they turned a corner too sharply that that contributed to the crash itself, then the judge would say, okay, the award of damages is $1 million. I find the plaintiff 25% contributory negligent in this accident. So while the damage award is $1 million, the judge will take $250,000 off the actual award to the plaintiff. And that's how that works. And lastly, a victim may also be disqualified for obtaining damages if they voluntarily assume the risk, right? The ice diver, basically. The risk must be obvious and there must be a clear indication on the part of the victim that he or she knowingly and voluntarily assumed the risk and participated in the activity, right? So again, if you go back to the ski hills, right? If somebody comes up to a black diamond on a ski hill and they know that they do not have sufficient skill to ski a black diamond slope, yet they do it anyway, then there's an assumption of liability that they're assuming, right? So to a great degree, they're assuming their own liability for harm that may be caused, right? Almost every sport, has on the back of the ticket, when you pay for the sport, a contract, and it is a binding contract that says if you do not follow the rules of the sport or the game or whatever you're doing, we will not be liable for your damages. So you find that on the back of ski tickets. You find it on the back of the tickets for hockey games, baseball games, basketball games. It's the fine print on the back of those. All sporting events have that fine print somewhere on a ticket or something you've purchased that will basically say that if you contribute to your own harm while attending this sport, we are not liable to you for whatever harm is caused. Okay, so I just have a couple of videos left and I'm not sure they're going to show again, but let's try them.
What sucks worse than this? It's dying in some old folks' home with a bedpan beside you. So the worst option ain't that bad, right? Oh yeah!
Go time, 23,000 people, show starring. Let's give them a real show. I'd have to say, hands down, that is the best entrance to any night circus show ever.
Let's go get it done.
Are you good with this, Wheels?
Oh, no.
All right, you want to come back down?
I don't know. Here, send me up a little further, but don't drop me.
No, you're good. We're not dropping you. You got it. A little further, bud. A little further. There you
on
go.
the edge. Nice and comfortable. Oh my gosh.
Isn't it cool?
No.
Best feeling ever.
No. 3, 2, 1. I'm gonna go in 3, 2, 1. See you guys.
Yeah, I did it!
Okay, so you may think that all those mountains and wherever they're jumping off of, where they're doing this, like nobody owns it, so there's no liability for the ownership of all that terrain. Well, in fact, there is. In a lot of cases, obviously, it's some form of government. A lot of those are in the United States, so the federal government owns all their park services. So again, these people doing the base jumping, under no circumstances, if their chutes don't open, are they going to be able to collect anything, right? Because it's a full assumption of liability by them. Okay, let's try this as well. Oh, we can't. All right, so they don't, YouTube, Facebook doesn't let me watch this or watch this because actually, this actually shows these things failing. And so every class I've taught sports law in over the course of the last 7 or 8 years have seen people slam into mountains or the ground kind of thing. So sorry, can't show that to you. All right, guys. Okay, so that is the lecture on negligence. So we're going to do the breakout questions now. So again, what I'm going to do is I'm going to send you to the, we're going to have 3 breakout rooms. I'll send you to it for about 12 minutes, just because it's the first one we've done. The questions are pretty straightforward, so it shouldn't take you that long to put an answer together. So I'll come and get you at about 20 to 9 for you to give your answers to the class. All right. See you in a few minutes, guys.